Welcome to the 13 Secrets of the Rich, or informed by 33-year California protection wealth attorney Rich Rydstrom. The bottom line topic is how to lock away profits and property with simplicity and without fear of lawsuits for medical professionals, doctors, dentists, chiropractors, and high net worth Californians. You work hard to achieve excellence in your profession, but medical professionals are susceptible to many risks. Lawsuit risks are notable, real, and seemingly endless, and may very well threaten your survival. We know insurance doesn't cover all risks and the extent of such runaway liability. Therefore, medical professionals and high net worth individuals must know how to lessen or contain the risks and structure their business and profits as a going concern. Specifically, we must know how to take monies, profits, and property out of the business, and lock it away for the owner's family estate and retirement. In this video I will show you how to do just that. Let's get started. So how do high net worth Californians lock away cash and valuable assets? The topic is pensions and the California Private Retirement Trust. In California, to protect cash and retirement property, we have one of the most powerful devices known as the statutory-styled Private Retirement Trust, or the PRT. It transforms non-exempt property into exempt property. That means, exempt from lawsuit judgments and bankruptcy. It's not just a pension holding device or trust. Let's stop here and discuss the PRT, as it should be the end goal of most business owners. Understand that contributions, accretions, and disbursements, to and from, the trust are protected from creditors by black-letter California law. That's powerful. The topic is converting non-exempt assets to exempt assets. In addition to homestead exemptions, which have limited but effective value, one of the most powerful retirement asset protection methods is converting the non-exempt assets to exempt status. This can be done as various ways, including by trusts, pensions, and marital or separate property or transmutation agreements. The PRT is one of the most powerful devices used to enhance an estate and business plan which protects the cash, wealth, equity, property, or assets transferred into this irrevocable trust for purposes of retirement. The authority of such a trust is a creation of California statute, which varies state to state. For example, in California, under its Code of Civil Procedure Section 704.115, all amounts held, controlled, or even distributed by a private retirement plan are exempt. This means that you could even transfer certain assets into an existing PRT pursuant to its retirement plan, during subsequent litigation or after a judgment, save fraudulent transfer. Typically, the retirement plan would be sponsored by an employer, typically your LLC or operating company, but without any obligation to fund or cover employees. The plan is non-qualified, therefore, allowing contributions far exceeding those of qualified plans, IRAs, solo 401k or pensions plans, and the trust does not require any IRS filings. No tax deduction is gained for such contributions. However, you may also have separate qualified plans. The contributions are generally determined in writing pursuant to an actuarial calculation based upon numerous retirement factors including age. Retirement property accretes in value or income but is usually property that supports your retirement, but may be cash, rentals, business or compensation interests, loans, licenses, leases, lien receivables, homes, boats, investments, coins, etc. Although you may build in a wide scope of functions, like borrowing from the plan, you must respect your own rules, and adhere to the rules in the plan to avoid disqualification or misuse. You can mimic defined benefit or profit-sharing pension plans, but without the limits on contributions, allowing for much higher contribution opportunities. Note that all amounts held, controlled, or in process of distribution by a private retirement plan, for the payment of benefits as an annuity, pension, retirement allowance, disability payment, or death benefit from a private retirement plan are exempt. This differs greatly from other exemption codes in California, such as California Code's Code of Civil Procedure Section 704.010 to 704.210, which is the individual retirement accounts, or IRAs. The topic is entities and business operations. First, most of us operate our business in an entity, like an LLC or corporation, whether as a C corporation or an S pass-through for tax purposes. Each is fine. But beyond tax reasons, medical professionals and high net worth individuals need to segregate risky activities, and lines of business from less risky activities, and valuable assets from operational assets. This is done typically with contracts and different entities and trusts. That alone affords a great measure of protection. However, that does not ensure protection of cash and valuable assets that you deserve to enjoy now and into your retirement. Of course, self-settled revocable living trusts are not asset protection devices during life. But living trusts are critical to avoid probate and act as the instructional quarterback for your personal and professional life. For example, medical equipment, X-ray machines, accounts receivable, intellectual property, or even real estate that you own should be isolated into its own respective entity, with its own contract defining that relationship with your operating business and/or you. Note that the different entities and the owners can supply loans, to or from same, licenses, leases, use of property or other value, whether real or personal property, or services to the other, in return for consideration, promises, or payment of money. For example, to the extent not restricted by a professional license, the professional may offer services from a loan-out entity to the operating entity in return for salary, bonuses, and automatically originating and liquidating secured liens on accounts receivable. The professional may contribute, or automatically assign, certain amounts to a private retirement trust. For licensing intellectual property, the professional may hold same in a separate entity, and license same for use in consideration of payments, royalties or other value, and build in automatic reversions in the event of failed milestones, lawsuits or judgments. The timing of this may also be key. Certain entities may have different tax years as well, and tax benefits may be realized within reason. Also, the return of property or repayment of loans may not be taxable events. Planning for expenses, loans and taxable income events, and matching income and loss characterizations, are a function that your CPA should review every 6 months. The topic is the IRA. IRAs are not fully protected under the asset protection laws found in federal ERISA protections. However, some states have enacted special but restrictive protections of IRA plans, protecting the funds and distributions only to the extent necessary for the support of the debtor, spouse, and dependents, as in California. The topic is the qualified ERISA plans. ERISA, Employee Retirement Income Security Act of 1974, supplies very effective asset protection over pension funds. The federal law overrides state law to the contrary and protects 401k, profit sharing and pension plans that prohibit involuntary assignment of plan benefits to any creditors. Assets may be transferred into such a plan with known creditors, lawsuits or judgments, save fraudulent transfers. However, ERISA will not protect such assets from the IRS or subject to court order in divorce court, or a qualified domestic relations order. Note that ERISA plans protect employees, but not owner-only plan participants. If the plan's only participants are the owner and his family, spouse or dependents, then ERISA may not apply to protect the funds. This section alone is also worth the price of admission. Listen to it again and consider it as an end goal of all your hard work. In closing, we end where we start. The most important lesson, contrary to what you may think, is to analyze your business and life together, based on its purposes and goals, lines of business and activities, and segregate each into its own entity, trust or device. That's the safety zone. In California, to protect cash and retirement property, we have one of the most powerful devices known as the statutory-styled Private Retirement Trust or the PRT. Well, I think we did it again. Congratulations for watching this video. Now you have to make an important decision to act and obtain the solution. You can book a call with attorney Rich Rydstrom at wealth.attorney. See the link in the video description or call 877-WIN-4U. Thanks again. Rich Rydstrom, California Attorney. Legal notice. IRS Circular 230 Disclosure Notice. To ensure compliance with IRS requirements, we inform you that any U.S. federal tax advice contained in this communication is not intended or written to be used, and cannot be used by any taxpayer, for the purposes of, I. avoiding penalties under the Internal Revenue Code or, e. promoting, marketing or recommending to another party any transaction or matter addressed herein. Any legal advice expressed in this message is being delivered to you solely for your use in connection with the matters addressed herein and may not be relied upon by any other person or entity or used for any other purpose without our prior written consent. This information is for general non-exhaustive educational purposes only. Each client has unique facts and some statement examples may or may not be appropriate or available for all clients. May be deemed an advertisement by the State Bar. All rights reserved in trademark and copyright. Copyright 2022 Rich Rydstrom, California Attorney. Call 877-WIN-4U. Email info@wealth.attorney.